Donc, j'ai le plaisir de vous présenter la professeure Eva-Maria KIENINGER. Nous nous connaissons depuis très longtemps, à peu près le délai de prescription maximal de 30 ans. Et nous nous connaissions parce qu'elle était assistante à Augsbourg du professeur Jürgen Basedow, qui est décédé malheureusement brutalement, il y a quelques mois. C'est une spécialiste de droit international privé, elle est professeure à Würzburg, et dès que nous avons trouvé le PowerPoint, elle nous expliquera le point de vue allemand, l'Allemagne possédant le EG-BGB, et donc une codification du droit international privé. Ce qui est intéressant, c'est que l'article 3 du EG-BGB fait référence justement à la situation déréglante par rapport au droit de l'Union et aux textes internationaux. Mais je ne veux pas empiéter sur ce que Eva-Maria KIENINGER va nous dire. Ah, super. Elle va nous parler en anglais.
Yes. Thank you very much for giving me the possibility to talk to you in English. I can understand French, but I think it's better that I talk English. I feel more comfortable with English. Yes. So I'll move a little bit to this side so that I can reach the PowerPoint presentation. Well, it's certainly with a feeling of admiration and envy that a German private international law scholar looks across the Rhine these days. A comprehensive draft code, including jurisdiction, applicable law, recognition and enforcement, as well as provisional measures, and of course, most importantly, a comprehensive general part, has never been attempted in Germany, nor will such a project take place in the foreseeable future. But it's not only the process of codification as such that lets us look up to our French colleagues, but also the courage to cover issues that in Germany have always been left to jurisprudence and doctrine, such as the method of classification, now Article 6 in the draft code, the ex officio application of conflicts rules, and the exceptions thereto, the issue of circumvention and fraus legis, and above all, the much debated definition of the habitual residence of a natural person. However, I do not want to enter into the rather fierce debate on the desirability of a national PIL codification in the face of the vast and growing body of European regulation. I will limit myself in a first part. Of course, I have a first part because I'm in France, so I have organized my talk in two parts and two subparts. I mean, although you will immediately recognize that it's not done the right way, because it's not thèse and antithèse. To some remarks on how to deal with a multi-layered system of contemporary PIL and highlight some problems concerning the French approach, using agency and assignment as practical examples. And in the second part, I will look at two areas where so far there's no European regulation, at least not strictly speaking, and that's international property law and company law. And I'm very thankful that you already touched upon these issues so that we can enter perhaps later into a discussion on these two special parts of the draft code. Well, it's a fact that every national PIL code has to take into account at least three different layers of sources: autonomous national PIL international conventions, and if it's a member state of the European Union, the European regulation. And in some areas, there's even a fourth source in the form of the jurisprudence of the European courts. So every national legislator of a member state, whether it builds on an existing partial codification like the German one or design a new code like in France, has to somehow accommodate these other non-autonomous sources. And I show you a slide on the varied experience that Germany has had over the past decades, and it's one of trial and error. Before the European legislative activity started, Germany used to incorporate most PIL treaties to which Germany was a state party, for example, the Rome Convention on the Law Applicable to Contractual Obligations of 1980, or the old 1956 Hague Convention on the Law Applicable to Maintenance Obligations, into its PIL codification without actually disclosing their true origin. This incorporation was meant to help practitioners finding the relevant rules. However, the doctrine has always been very critical of this approach, because this approach gave the false impression that those rules were autonomous law, thus impeding their internationally uniform interpretation. And some commentators and courts even took the view that the national rules were inapplicable. When the first European regulation, that was Rome II, was about to enter into force, the legislator did not dare to go down the same road. And I very well remember the discussions in this, within the German Council on Private International Law with the Justice Ministry, and they were absolutely against that incorporation method. And because they were afraid that they would trespass on the direct applicability of regulations and possibly violate European law. And therefore, Article 3 of the EGBGB only lists the European regulation and states in a very general manner that the following enactment only applies to cases which are not covered by those regulations. But if you, for example, take a look at Article 40 EGBGB on the delict, on tort, on extra-contractual liability, one will find the autonomous rules without any qualification of their applicability or any reference to the Rome II regulation. And that is creating, I think, the danger that the regulation, if you only look at those rules, will get overlooked in practice. In other instances where the possible lacuna of the regulation were less visible, I mean, with the Rome II regulation, which exempts infringements of personality rights, it's quite obvious that there are carve-outs of the regulation. But for example, with the Rome I regulation, it was less obvious. And what happened there is that the rules in the EGBGB were dropped altogether. They were deleted from the statute book. And in 2015, for example, when the EU became a party to the 2005 Hague Convention on Choice of Court Agreements, German PIL scholars suddenly realized that there were no rules left on the law applicable to the conclusion and the validity of choice of court agreements, because Rome I exempts choice of court clauses from its scopes, and the national rules had been deleted altogether. And the same happened with the divorce, with private divorces after the Sahuni decision of the Court of Justice. And the German legislator was again caught on the wrong foot, as we would say, and it had to step in and create a separate rule on private divorces, which is now in Article 17 of the EGBGB, mainly referring to Rome III regulation, but with some fine-tuned deviations, for example, in relation to the ordre public. And after that, and that's the third stage, Germany had learned its lesson. With the introduction of the succession regulation, Germany introduced a new technique, and Article 25 EGBGB, which formerly contained the basic rule on succession, now says if aspects of succession do not fall within the EU succession regulation, the rules on the regulation are to be applied by way of analogy. So that's the technique nowadays. And I have the impression that this last stage of the German way of dealing with the European regulation is now mirrored by those provisions in the French draft, which for each subject set out the applicable regulation and state that where the regulations exempt certain issues from its scope, it shall nevertheless apply by virtue of autonomous law. If one aims at a comprehensive codification, I don't see any other road which one could possibly take. The only remaining question is, should one aim at such a code? And does the code help? And my next slide is on this topic. Does the draft code help? When it comes to international conventions, the obvious problem lies in the fact that there are too many and that they are very heterogeneous. Therefore, the French draft refrains from enumerating them, but in the first article of each section, it simply says it reserves any international conventions to which France is bound. And it has already been criticized in the French debate that this does not enhance the accessibility of private international for a layperson or a practitioner who only occasionally deals with a cross-border case. And I present to you an example. Agency is exempted from Rome I, and when I looked at the French draft, I was very curious to see how this subject was now being regulated, bearing in mind that Germany only codified its jurisprudence in 2017 with a new Article 8, EGBGB, on agency. Finding nothing in the French draft code on agency, I turned to the conventions, and of course, France is one of 4 state parties at Argentine, France, Netherlands, and Portugal to the 1978 Hague Convention. Since Germany is not a party to the Hague Convention, and Article 8 EGBGB excludes renvoi, so that German courts will not even apply the convention via renvoi, I was sort of the layperson who only occasionally dealt with French PIL, and I must say that the draft code was no help in detecting that agency in France was covered by the Hague Convention. So much for my self-experiment. Another area which is very hotly debated in Germany and in the EU is assignment of claims. It is therefore quite a surprise that there is no explicit rule on assignment in the draft code. The notion cession only appears in the context of Article 31, which deals with jurisdiction clauses. Such clauses are transferred in the case of an assignment together with the assigned right or claim. Other than that, if I'm not totally mistaken, the draft does not touch upon assignment. Although on the level of substantive law, both institutions, the assignment of claims and the assignment of contracts, have just received a thorough update in the French Code Civil, so that came to me as a surprise. Of course, a larger part of assignment law is contract law and is therefore covered by Article 14 of the regulation, and Article 14.1, which you see on the PowerPoint, relates to the obligations between assignor and assignee, for example, resulting from a sale or a pledge of the receivable, and subsection 2 governs the relationship between the assignee and the debtor. For example, whether the debtor can invoke vis-à-vis the assignee any payments which he still made to the assignor, or whether he can still set off any claims that he himself owns against the assignor. What's not covered, however, is the opposabilité of the assignment as against third parties, such as creditors of the assignor and the assignee, or different assignees of the same claim. The most straightforward case of such a priority conflict, as it's called, is a case that has recently been decided by or not been decided, rather, by the European Court of Justice, and it has been referred back to the German court. And the case is rather simple. An employee of a museum in Luxembourg who lived in Germany needed to give security for a loan from a German bank. And she transferred her salary claims as security to the bank. The whole contract was, of course, governed by German law. Afterwards, she ran into more financial difficulties and she took a second loan from a Luxembourg bank. And again, and this time under Luxembourg law, she pledged the same salary claims as security to the Luxembourg bank. And the Luxembourg bank then notified the employer of the pledge. Upon insolvency of this customer, both banks wanted to lay their hands on the salary claims. But which law governs the priority conflict? If it's German law, the German bank wins, because under German law, the security assignment needs nothing more than the assignment contract itself, and therefore the salary claims had been transferred to the German bank, and there was nothing which the customer, this employee, could still transfer or pledge to the bank in Luxembourg. If it was Luxembourg law, the first assignment would not be opposable, since the German bank had not notified the employer, which is necessary under Luxembourg law. So clearly, the Luxembourg bank would win the priority conflict. The case was referred to the Court of Justice, who refrained from giving any solution. It stated instead that the conflict between two assignees of the same claim touched upon the proprietary effects of assignments, and that these were outside the scope of the Rome I regulation, and that it was therefore for autonomous PIL to decide. And as I said before, since Germany had deleted from its statute book the rules on contracts and international contracts, Article 33, which previously incorporated the old Article 12 of the Rome Convention into national law, was gone. So there was nothing left. So the OLG Saarbrücken, the court which had referred the case to the European Court, simply said it would adhere to the old jurisprudence of the BGH from 30 years back, and would apply which is now Article 14, subsection 2 of the Rome I regulation, to the priority conflict. And of course, I was very curious to see, since I've also been a member of the expert group with the European Commission, which then led to the 2018 proposal from the Commission, which is still pending somewhere in the Parliament. I have no idea what's happening. And so I was very curious to see what the French draft would say, and I didn't see anything. It seems to me that the chapter on droit réel, although I've realized that the definition of bien is wider than Sachen, which are only corporeal movables in German law, bien seems to be wider, but that it doesn't apply to that's it. That's the PR code. And also that the connecting factor, the citus, doesn't seem to me to be something that should be chosen as a connecting factor for assignment. One can, of course, argue that the lex citus is able to serve as a connecting factor for claims, and one can invoke the traditional rule that the citus of claim is the location of a debtor, and as long as French law still required the notification for an assignment to become opposable, I think this rule would be in harmony, or would have been in harmony with substantive law. But according to the new Code Civil, notification of the debtor is no longer necessary for the possibility of the assignment as against third parties other than the debtor. And also in other jurisdictions, courts and doctrine have moved away from the location of the debtor as a possible connecting factor for the property effects. The much debated solution of the Dutch jurisprudence, which favored the law of the assignment contract, has also lost ground. Today, it's only two connecting factors which are still on the plate, the law of the assigned receivable and the commi of the assignor. When one turns to the draft code and the chapter on contractual obligations, one could argue that assignment is covered by Article 89, so that Rome I should apply, yet it does not clarify which rule in Article 14, the law of the assignment contract, or the law of the assigned receivable. Well, I will move to my part 2, section A, and that is concerns now areas which are untouched by European regulation, although not European law, and we'll see that. And property law is, of course, among those subjects which have only been slightly touched by the European legislator at the margins. Article 24, number 1, Brussels 1A regulation, succession regulation, especially after the famous Kubitzka case. But the core of international property law is still autonomous law. As a matter of principle, the draft code sticks to the lex citus. I agree that this is still a good starting point, even if some authors advocate for a greater role for party autonomy, even in property law. And regarding the general rule in Article 19.8 on the modes of acquisition, I very much welcome what you've already pointed out to us, that it tries to fix the time at which the lex citus is to be determined, le lieu de situation du bien au jour où ce droit est invoqué. By way of contrast, the JDIP proposal has no such element. Article 4 says just proprietary rights in an asset are governed by the law of the state within the territory of which the asset is located. But although I think it's a very good idea to fix the moment, I'm not so sure about the choice of that moment. What does the time when the right is invoked mean? And I want to take a very simple example. Let's take an individual movable asset. Let's take an antique chair, and it was purchased in France by a German buyer. The parties agree that the vendor should send the chair to Germany, to the German home of the buyer. The chair is delivered to Germany, but accidentally not to the buyer, but to his neighbor. And the neighbor adores the chair and refuses to hand it over. The buyer now claims the chair from the neighbor as its property. Does the buyer own the chair under this rule? As long as the chair was in France, the buyer already was its owner. Had he invoked his ownership there, French law would have applied. But the buyer invokes his ownership only now, since when the chair is in Germany. So German law applies under Article 98. Under German law, the buyer has not yet given possession, unless one regards the carrier as an indirect possessor for the buyer. So he's not the owner. Article 102, with its recognition of foreign rights, does not apply because that only applies to security rights. And the simple ownership is not a security right here. So I'm absolutely sure that the draft does not intend this result, but I find the wording on the date at which the right is invoked highly misleading. I would suggest to apply the lex situs as at the moment when the transaction took place or the right is purported to have been acquired or come into existence, not when it's invoked. And this would also be in conformity with Article 100 of the Code, which submits the content and the rights flowing from a real right to the law of the place at the time when the right is exercised. However, one can only exercise a right that one has acquired. The rule that the moment of acquisition or creation should be the relevant point in time has also been chosen by the recent Dutch codification of international property law, and that's shown here on the slide. And you see, decisive for the purpose of the previous paragraph shall be the moment on which, I mean, the English translation is very good. I don't know whether that comes from Google Translator, but of the previous paragraph shall be the moment on which the legal facts required for such action take place. Another point in the chapter on property law. The French draft only has unilateral rules on recognition and res in transitu. These rules have very much been drafted from a French point of view. They talk about the modes of acquisition, opposabilité. Some of them are only unilateral, as I said, rule on recognition or res in transitu. Of course, in most instances, French courts will have jurisdiction over assets situated in France, but that does not always have to be the case. Let us suppose a movable asset that was pledged by a French company to a French bank while the asset was in France, but then it was brought to Belgium. In the event of default, the French bank wants to claim repossession from the pledgor, and the asset is in Belgium. Which law should a French court apply? Under Article 101, it seems to be Belgian law, but Article 102 and Article 103 say nothing about the treatment of the security right under Belgian law. It is evident that French PIL cannot prescribe how Belgian courts should treat a French security right. But if the case comes in front of a French court, why should the French court not uphold the rights of the original French pledgee as far as they are not contrary to Belgian law, or at least transpose those rights to their Belgian equivalent? So I would think that those rules could be made multilateral, or they do not have to stay unilateral. And again, I think that the JDIP draft here, and no, not again, but here, I think that the JDIP draft is clearer because it's multilateral. And I'm not going to read it out to you. It is to be found on the website of the Groupe Européen de Droit International Privé. Another issue, and you've pointed out that, we've been listening to the argument that it's very good that in the part on company law, the French draft sets out, has a provision on the scope. But in property law, there's no provision on the scope. And I find this it's not so natural to know what is exactly the scope of international property law. And here I've taken the example, one could also take the example of the JDIP draft and others, but here I've taken the example from the Dutch codification, because we don't have a Dutch colleague with us this morning. And I think that's a very good example for such a rule on scope. And that's also a point of accessibility. So that would enhance accessibility. And my fourth point on property law is that there are no special rules on means of transportation. And really, I think that must be corrected before the draft code comes into force. It's very odd because practically all member states have special rules on aircraft, vessels, and trains, submitting real rights to the state of nationality or registration. it seems to me that the French doctrine is of the same view, but I would be afraid that once such a rule gets codified, or the absence of such a special rule gets codified, it becomes more complicated to stick to that doctrine, and it would be better that such doctrine is also reflected in the statute book. And my last point, and I don't have a slide on that, is I find that the chapter on property law lacks an element of innovation, really. It sticks to the traditional rules. One could think of some elements of innovation. For example, if one were to choose for cars and security rights over cars as a connecting factor, the place of registration, as is done, for example, in Portugal, this would do away with like 90% of all cases on conflit mobile that are commercially relevant. Another example would be limited party autonomy for goods destined for exportation, that's in the Dutch enactment, or grace period for the fulfillment of publicity formalities once the incumbent asset has been introduced in France, or a special rule for the acquisition of non-domino of cultural property, the lex originis, as it's done in the supplement to the JDIC draft. It seems to me that property law was not so much in the forefront of the drafters' attention, that recent national and European developments have not been sufficiently taken into account, and that the whole approach to property law is rather conservative. And I think that's deplorable because it's a subject where there's still room for autonomous legislation and where innovation might set an example for a future European regulation, which I'm certain will come about in the coming years or maybe decades, I don't know. And I turn very briefly to company law, and I can be very brief because you've already set out that now the general rule will be the state of registration or the state of the statutory seat of the company. And I will skip a little bit my remarks on the drafting technique, and I will come straight to the policy issues. I agree with the drafters that applying the law of the statutory seat to all companies, those founded within the EU and those from third states alike, greatly simplifies the PIL rules. And that's especially compared with German private national law, where the jurisprudence still distinguishes between EU companies, statutory seat, and non-EU companies like Switzerland, where it still adheres to the real seat as the connecting factor. But, and for many, many years, I've been very much in favor of this uniform rule, statutory seat, whether it's a EU company or non-EU company. And one can argue that it does not make great sense to fight against intransparency and the famous race to the bottom by sticking to the real seat theory when courts are, on the other hand, like the German courts are, forced by international conventions such as the European Free Trade Area or the US-German treaty to apply the incorporation theory to companies from Liechtenstein or from Delaware. So why should we then apply the real seat theory to Swiss companies? And shall we really discriminate against them or now, since the Brexit, against UK companies? And that was also, this uniform rule was also the proposal from the German Council on Private International Law in 2006 in the aftermath of the Überseering judgment. This proposal was taken up by the German government, but it never saw the light of the statute book. Now, 15 years later, I tend, I must say, to be more hesitant. Take the recent example of the Russian oligarch Usmanov, who since many years walks in and out of two nice villas at the Tegernsee, south of Munich. If you look into the land registry, and I don't know whether you can see it on the slide, the land is not owned by Mr. Usmanov himself, but by two Isle of Man vehicles. Mm-hmm. And if you look under this postal address, according to the Panama Papers and the Paradise Papers, it's like 200 other limiteds are registered under the same address. The transparency register at the time was limited to German companies, and there was no possibility for the German authorities to find out who in fact is behind those Isle of Man limiteds. And as long as Germany still adheres to the real seat theory with respect to third states, such as the Isle of Man, one could at least argue that the shareholders of those vehicles are in reality, if the real seat of the Tegernsee Lakeview Limited is in Tegernsee, they are in reality partners of an unlimited partnership, with a partnership with unlimited liability, and therefore the inscription in the land registry is wrong, as it's now on the registry. All partners would have to be entered with their personal names. With our recent experience in the wake of the Russian war against Ukraine, I tend to look at preserving the real seat theory for third state companies a bit more favorably. We should hesitate to apply the law of incorporation to all companies incorporated in tax havens and other states without proper rules against money laundering, international organized crime. Should we not fight against criminal behavior by using the real seat theory and by holding the shareholders of such vehicles personally liable if it turns out that their real seat is not at their place of registration? And I don't know whether that is meant by Article 85 of the draft PIL code with the fraude au droit de tiers, whether that's the case for this provision. That's my last slide. I would like to come back to the two general questions which have been in the center of the French debate. Should one not wait for a European PIL codification, especially when it comes to the general part? And is it helpful to have a PIL code as an entry point? And to both questions, I will give a rather pragmatic and therefore German answer. I think that a European PIL code or even a European general part, the famous Rome Zero regulation, will not become a reality anytime soon. And the simple reason is Article 81, subsection 3 of the Treaty on the Functioning of the European Union, which requires unanimity for international family law, and which has led to an enhanced cooperation for the various family law regulations with different groups of participating states. And such a rule would, of course, also apply to any Rome Zero regulation if one were to include the family regulation. If one doesn't include them, why have a Rome Zero regulation? And as to the second point, and you already see my dream, the helpfulness of such a draft, I take a positive point of view. As a teacher of private international law, I find the draft code very instructive. It gives everyone, student, practitioner alike, dealing with the subject for the first time or only occasionally, an accessible entry point, and most importantly, informs the reader of the existing EU regulations. And it's no small advantage in the eyes of a German scholar that it will allow any German-style article-by-article commentary to be structured in a likewise easily accessible way. And thank you very much.
Merci beaucoup à tous deux pour ces analyses de parties différentes, du projet, ce qui enrichit encore notre vision. Le professeur Butler était plus généraliste, a couvert pratiquement tout le code, et Eva-Maria KIENINGER, la professeure KIENINGER, s'est prononcée plus sur des aspects de droit effectivement spécifiques, droit des sociétés, droit réel, etc. Nous avons un peu de temps pour le débat. Enfin, oui, on a du temps. Un quart d'heure? Voilà, 10 minutes, un quart d'heure, la parole circule. Qui souhaite formuler questions ou remarques? Tout le monde peut parler français. La professeure KIENINGER comprend le français. Elle répondra peut-être en anglais, mais elle comprendra parfaitement les questions. Oui.
Everyone wants coffee.
je suis très gêné de prendre la parole, mais je voudrais simplement peut-être éclairer deux observations. Je vous remercie très sincèrement de vos remarques à la fois génériques et plus spécifiques. Peut-être expliquer effectivement certains points qui rejoignent peut-être d'ailleurs le dernier slide, votre dernier slide. Vous avez évoqué effectivement la démarche qui est, qu'en est-il du contrat de représentation, du contrat d'agence, effectivement pour un juriste de droit international privé allemand qui voudrait se retrouver dans une situation de droit français. C'est vrai que c'est une des très grandes difficultés, mais qui pour le coup est proprement française, puisque nous sommes un pays qui adore signer et ratifier des conventions internationales. On s'est amusé en période de Covid, puisqu'on n'avait pas grand-chose d'autre à faire, à regarder en droit international privé combien de conventions s'appliquaient en France. On arrive quasiment à 300. Et l'une des difficultés qui s'est posée, c'était, hormis dans certains cas, exemple la Convention de La Haye sur les régimes matrimoniaux, où là, il y a une mention expresse, à devoir procéder à des mécanismes de renvoi permanent pour dire, ben là, c'est telle convention de La Haye, là, c'est telle convention CNUTSI et autres. Sans trahir de secret, le ministère de la Justice n'aimait pas forcément beaucoup la technique de renvoi que l'on a utilisée. Pourquoi ? Parce que ça veut dire, et c'est une des difficultés qui, je sais, existe en Belgique, qu'à intervalles réguliers, il faudra mettre à jour le code, d'où la disposition un peu générale qui est faite. Et dans votre exemple que vous avez donné, où effectivement on ne trouve pas de règle de conflit sur la représentation ou le mandat, puisqu'en réalité tout ça est traité par la Convention de La Haye, à laquelle la France est partie, dans le silence du règlement Rome 1. L'idée aurait été d'avoir peut-être un 208e article qui aurait procédé à un mécanisme de renvoi en disant voilà toutes les conventions et qu'il faut connaître quand on fait du droit international privé. Problème, cet article n'est pas normatif. Or, là, c'est plus le problème du cavalier législatif, c'est le problème, pour reprendre le vocabulaire du Conseil constitutionnel, des neutrons législatifs. Le neutron législatif, qui est une très jolie formule inventée par un ancien président du Conseil constitutionnel, c'est-à-dire une disposition qui n'a aucun contenu juridique. Et le raisonnement qui a été le nôtre est de dire que si le code voit le jour, nos amis les éditeurs juridiques s'en emprunteront, enfin son nom, comment dire, vont s'en saisir plus exactement, et que précisément dans ce qu'on va appeler des codes éditeurs, c'est typiquement le genre de situation qui relèverait de leur travail. Vous connaissez tous ce magnifique ouvrage sur les grands textes du droit international privé français, dont la dernière édition est parue il y a quelques jours. Vous trouvez effectivement ces éléments-là. Et c'est là où un commentaire plus général du code, à l'image effectivement du commentaire article par article dont la doctrine allemande est extrêmement friande et qui commence à vraiment trouver sa portée en France, ça pourrait être une solution. Je ne reviendrai pas sur la question des droits réels. Alors, sur la question très particulière des cessions, c'est vrai qu'il y a la proposition de règlement. Alors, je suis comme vous, je ne sais pas où il est. Enfin, il est quelque part, certainement, mais on ne sait pas où il est. Mais à nouveau, le ministère a dit, mais on ne va pas aller travailler sur ce sujet-là si demain il y a un règlement de l'Union. C'est un dernier problème. Alors, vous allez me dire, ça n'a pas empêché de traiter, par exemple, la question de l'affiliation. Alors, c'est vrai que le code a été remis à une époque où on ne connaissait pas la proposition de règlement dessus, ou la question des adultes vulnérables, parce qu'on ne connaissait pas la proposition de règlement sur les adultes vulnérables. Mais ça, c'est une des difficultés majeures des codifications nationales. Et je veux dire, tous les États membres vont être confrontés à cette situation, puisque, comme on le sait depuis un colloque magnifique qui s'est tenu, même si je l'ai suivi à distance, à Louvain, comme vous l'avez rappelé, Rome 0, Bruxelles 0, c'est parti dans les limbes. Enfin, je pense qu'on sera tous à la retraite, et Dieu sait qu'on part tard à la retraite en France. On sera tous à la retraite avant que on voit quelque chose en la matière. En tout cas, merci beaucoup de vos réflexions. Puis, dernière petite observation, sur l'article 17. Bien sûr que c'est totalement délibéré, l'article 17. Pour une considération simple, qui est une considération d'ordre pratique. C'est qu'un certain nombre des membres du groupe, qui, en dehors d'une activité universitaire, peuvent avoir une activité de praticien, savent que dans un grand nombre de situations, et je ne vise pas les personnes physiques, je pense surtout aux personnes morales, il peut être quand même extrêmement utile pour une petite PME française qui travaille à l'international de pouvoir venir voir le juge français. Alors oui, il y a le fort de nécessité. Mais les conditions sont quand même, j'allais dire, délicates à mettre en œuvre. Et il me semble qu'avec toutes les réserves qui ont été faites, je ne vois pas pourquoi on désarmerait la compétence juridictionnelle internationale du juge français.
Peut-être juste une remarque sur ce que tu viens de dire, Cyril, à propos des éditeurs qui finalement s'empareraient de la manne concernant effectivement non seulement la publication d'un code commenté, pourquoi pas, de droit international privé, mais également les renvois nécessaires aux différents textes internationaux. Moi, je trouve que c'est une question d'intérêt public et ça m'ennuie quand même de renvoyer cela à des éditeurs privés. Je me demande si ça ne serait pas la tâche du ministère de la Justice, transparence oblige, d'avoir sur le site, avec l'aide du Bureau international de la justice, la mise à jour constante de cet outil qui devrait pouvoir être accessible gratuitement.
Tout à fait d'accord avec toi.
Ou pas ce que je dis, moi, ça me paraît quand même...
Je suis 100% d'accord avec toi, sauf qu'on est en France. Et qu'en France, vous avez des baronnies ou des chapelles. Et vous n'aura pas échappé que qui dit convention internationale dit ministère des Affaires étrangères.
C'est vrai. Ah oui, c'est vrai.
Et que le débat, qui n'est pas qu'un débat purement financier, quoique, c'est mettre en place un site où il y aurait toutes les conventions. Il est censé exister. Je vous mets au défi de trouver un grand nombre de conventions bilatérales qui lient la France, ne serait-ce que par exemple avec d'anciennes possessions. Et la chancellerie vous dire, mais c'est pas d'où. C'est le ministère des Affaires étrangères. Le ministère des Affaires étrangères dire, ah ben non, ça doit être le ministère et voilà. Mais on est en France.
Oui.
Merci beaucoup. Est-ce que je peux réagir sur les neutrons législatifs? Parce que je ne connaissais pas l'expression, elle m'interpelle. Je pense la comprendre. Mais alors, j'ai une question, puisque finalement, est-ce que cette appellation ne pourrait pas être aussi étendue à certaines dispositions qui sont des dispositions de renvoi? Il y en a plusieurs. C'est vraiment très sophistiqué, hein, cet appareil. Je n'ai pas voulu entrer dans ce débat, je savais bien que ça allait être sur la table. Mais il y a des dispositions de renvoi qui sont différentes. Sur les régimes matrimoniaux, elle va beaucoup plus loin, puisqu'elle ne se contente pas de faire référence aux conventions, elle les ordonne par ordre chronologique. C'est l'article 72. Mais si on prend l'article 78 ou 79, finalement, quelle est la valeur normative propre d'un article 79? Ou bien prenons en matière de succession l'article 83. Quelle est la valeur normative propre d'un article 83 qui nous dit que le droit applicable de succession est déterminé par le règlement? Est-ce que ce n'est pas là aussi une manière de neutron législatif? Est-ce qu'on ne risque pas d'avoir une censure du Conseil constitutionnel? Je le dis parce qu'en Belgique, on a ces dispositions et j'ai coutume de dire que légistiquement, on peut s'interroger sur, disons, sur le caractère approprié. Ceci étant, nous les appelons des règles de signalisation et je trouve qu'elles sont éminemment utiles pour les praticiens.
Voilà. Non, mais tu as mis le doigt sur cette réalité. Clairement, ça n'a aucune espèce de valeur normative. Ça, mais ce qui nous aide, c'est les déclarations du président de la Commission supérieure de codification qui dit que l'exercice de codification, et comme c'est un conseiller d'État, il a forcément raison, eh bien, qui dit qu'aujourd'hui, dans la codification, il y a une dimension nécessairement pédagogique. Donc, il peut y avoir des dispositions de pédagogie. Mais le souhait, et je le comprends parfaitement, parce qu'un conseiller d'État ne dit pas forcément la même chose selon qu'il siège au Conseil d'État ou selon qu'il est en détachement ailleurs, c'est d'éviter, en tant que faire se peut, la multiplication de ces fameux neutrons législatifs. Et ce qui était assez emblématique, c'était un article final. Vous avez vu qu'il y a des dispositions finales sur l'application territoriale du code, parce que là aussi, la France est un pays extraordinaire, où ce qui est vrai pour certains des territoires n'est pas vrai pour d'autres territoires. De même qu'il fallait procéder à des mesures d'abrogation d'un certain nombre de textes. Nous, notre souhait, c'était d'avoir une espèce d'article qui aurait dit, voilà la liste des conventions qui sont applicables. Mais techniquement, a priori, mais tout ceci est dans les mains de la Commission de codification et du Conseil d'État, donc on verra bien ce qu'ils diront. L'enjeu, il est là, mais je ne vois pas comment on peut faire effectivement un code national dans un contexte européen sans avoir ce qui a clairement inspiré, c'est un emprunt à la technique belge, d'avoir ces fameux articles d'articulation, de renvoi vers les discussions. Parce que le praticien, et votre observation est l'illustration parfaite, j'ai un contrat d'agence commerciale, je veux chercher la loi applicable, bah, effectivement, je vais regarder le code de DIP français. Aujourd'hui, je n'ai pas la réponse parce que je sais que ce n'est pas dans Romain. Mais en fait, il faut que je sache que la France a signé et ratifié la Convention de l'Haye qui va s'appliquer. Les cours de cassation appliquent régulièrement en plus cette convention. Et ça, c'est une des difficultés. Alors bon, peut-être que effectivement, c'est un peu dommageable que ce soit les éditeurs, sous-entendus privés, qui suppléent les carences du dispositif étatique. Ou alors, on se projette dans un droit international privé de zéro et on imagine un code totalement dématérialisé qui aurait des systèmes de liens hypertextes. Mais ça, c'est pour Ludovic, c'est le spécialiste de ce fantasme.
Du numérique.
Moi, j'aurais juste souhaité réagir sur les neutrons législatifs, juste pour une remarque de méfiance. Les neutrons législatifs sont pas tous censés le demeurer. Et on a parfois des neutrons qui deviennent très actifs, qui deviennent des protons ou des électrons, si on veut poursuivre la métaphore. Il faut donc simplement se méfier. Si on reprend la règle que vous évoquiez, monsieur Vautelet, le droit applicable aux successions est déterminé par le règlement succession. Il y a aussi une potentielle extension finalement du règlement qui réside derrière. Et en vérité, à la marge, pour les questions non réglées par le règlement succession, la règle de conflit de loi, plutôt ici ce ne serait pas une règle de conflit de loi, mais ce serait une règle d'extension du droit de l'Union avec toutes les conséquences. Et là on retombe sur une autre petite question qui serait celle de la cohérence des extensions et de la formulation des extensions, parce qu'on voit qu'ici la rédaction est totalement différente de celle choisie pour l'extension du règlement Rome 1, où on a un alinéa dédié, et dans le coup on ne sait plus où se cache l'extension, où est-ce qu'elle n'est pas, dans quelle mesure elle est tacite ou explicite, et donc le neutron ne l'est plus totalement, et dans une argumentation, on pourrait facilement retourner le texte dans un sens qu'il n'avait pas à l'origine.
Simplement pour répondre sur ce point, ce que tu dis est parfaitement exact, c'est simplement de la considération d'ordre matériel. C'est-à-dire que, clairement, le champ d'application du règlement succession, je ne vais pas dire ça devant son brillant commentateur autorisé, le champ d'application du règlement, il est tellement large que les hypothèses qui échapperaient au règlement sont des hypothèses que je ne vois pas surgir. Et en tout cas, lorsque la commission, le groupe de travail a entendu les praticiens que sont les notaires, c'était l'aspect qui à l'inverse, il s'était beaucoup plus réservé sur le fait, par exemple, à propos des régimes matrimoniaux, que l'on n'ait pas procédé à une consolidation de la règle de conflit avant la Convention de l'Haye 92, puisqu'en France, on a quand même cette chose extraordinaire qui est que nous avons 3 systèmes de règles de conflit de loi en fonction de la date du mariage. Et là, c'est le seul cas d'ailleurs de dérogation à l'application, à la fameuse application dans le temps. Parce qu'on a, en succession, on a dit les successions, c'est le règlement. On n'a pas rappelé le système scissionniste antérieur à 2015. On l'a fait pour les régimes matrimoniaux pour une raison très simple. C'est qu'il suffit de regarder la jurisprudence de la première chambre civile pour voir qu'on est encore dans des problèmes de détermination des régimes matrimoniaux d'époux mariés avant 92. Et je fais référence à un arrêt très récent, absolument remarquable, dans sa formulation. D'ailleurs, la Cour de cassation nous a proposé une très belle formulation de la règle de conflit. Je ne désespère pas qu'on puisse la consolider dans le code, ça serait merveilleux. Mais là aussi, le ministère vous dit, attention, si vous rédigez une solution jurisprudentielle, d'abord, on n'avait pas le droit de le faire d'après la lettre de mission, il ne faudrait pas que, par la rédaction, vous apportiez une nuance à l'état de la jurisprudence pour qu'on vienne ensuite nous dire, attention, responsabilité de l'État, la règle, il fallait la comprendre comme ça, elle ne voulait pas dire ça, et on a ce problème. Ah oui, c'est ça la difficulté. La seule référence à la Convention de l'Haye pour les époux mariés entre 92 et 2019, puis du règlement à partir de 2019.
Une dernière prise de parole, oui.
C'est une question en fait pour Cyril, si je peux. Parce que tu as évoqué le grand nombre de conventions internationales qui sont en vigueur pour la France. Le même problème se pose en Italie, peut-être dans une mesure un peu moindre. Mais je me demandais si la codification ne pourrait pas être l'occasion pour faire du ménage et travailler éventuellement à une analyse de l'utilité actuelle de certaines conventions. Je pense par exemple à la Convention de La Haye de 1955 sur la loi applicable à la vente. C'est une convention dont la conception est très ancienne, qui est pourtant en principe assez importante. Et je ne vois pas de raison de la garder, en fait. Je ne sais pas si cet exercice fait partie de ce que les auteurs de la codification considèrent.
Ça, effectivement, ce n'était pas du tout dans la mission qui a été donnée par la lettre de mission de Madame Belloubet. C'est évidemment un sujet qui a été abordé lors de la soixantaine de réunions en tant que tel. On est un certain nombre, sans trahir de secret, à penser qu'il y a un toilettage absolument nécessaire. Mais je vais devoir à nouveau dire que le problème, c'est qu'on est en France. Et que la question de la dénonciation des conventions internationales ne relève pas du ministère de la Justice, mais du ministère des Affaires étrangères. Et donc, le ministère de la Justice dit je ne peux pas faire.
On fait une petite pause café. Quelle est la durée de la pause, Ludovic?
Nous allons faire une pause de 15 minutes et vous êtes tous invités à venir prendre un café en salle Boris Stark.
Boris Stark, 15 minutes.